It's day 30 of the Karen Read Retrial. Today, we are starting out with argument. We saw the attorneys saying that they were going to bring things before the court at the beginning of court today. And when the court said everybody needs to be ready around like 9:20, I thought she meant ready for the jury because she gave the jury an extra half hour this morning and they were going to give themselves like a half hour and started like 9. No, that's not what they did at all. So court didn't start until just a little bit ago. So we are going to be getting into court before the jury comes in as they are doing arguments. I don't know why they didn't give themselves a full half hour. I really don't. I don't know if stuff was filed and the court was in chambers reading it or if people weren't there. I don't know. But we're going to go to court and see argument. The defense has 2 witnesses left. One's already on the stand, Dr. Laposata. I imagine we're going to see the defense arguing again about Dr. Laposata being able to testify as an expert regarding dog bites. We also know that the defense is unhappy with the admonition the court gave to the jury yesterday. That shouldn't have just been an instruction. That should have also been an admonition. Attorney Brennan said or asked, and I went back yesterday and rewatched what the court indicated she was going to say before she got upset with the defense for conferring with each other while she was on the bench. And she was saying, Attorney Brennan asked about this. That should be stricken. And I think she still should tell the jury that that information should be stricken. She didn't. It was not enough of an admonition for me. The defense should have had time to confer and ask for a stronger admonition. She told them it was going to be stronger, and then it wasn't. The court needed to give a stronger admonition so it's clear to the jury that those holes were there from the crime lab, that the attorney was aware of it, that they were not there from the 29th, and those pictures need to be in evidence. The court said she was putting in evidence. She needs to tell the jury to stricken the question, and now she's going to have to remind them what it was because it's no longer close in time. I think a much stronger admonition, not just an instruction, is needed. I'm not surprised that the defense said at the end of the court day yesterday that they will be bringing it back to the court's attention and putting it in writing. And I think that's what we're going to see them do today.
We are asking the court to reconsider the court's ruling yesterday concerning Dr. Laposata and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. Last night, we pulled the tape. Dr. Russell was cross-examined by...
They used the timestamps and went back and looked. Okay.
Mr. Brennan, on the issue specifically of Dr. Laposata and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell
on that cross-examination.
Specifically on the issue of whether or not she had seen Dr. Laposata's reports, whether she was aware of Dr. Laposata's opinions, implying that Dr. Laposata had opinions about the dog bites. She was asked if she was familiar with Dr. Laposata's credentials. Dr. Russell said, yes, she was familiar with Dr. Laposata by name, that she thought she had impeccable credentials.
Yes.
And she very much wished she could have seen her reports as it relates to dog bites.
Yes.
It was an intellectual curiosity by Dr. Russell that was evoked.
She went looking for
and
it
elicited
in the file
by Mr. Brennan on cross-examination of Dr.
Russell wanted the tea.
So I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved.
Objection. The court says your rights are saved, meaning you can appeal it if you need to. I think the defense made a strong argument about the Commonwealth opening the door. I don't think we're done with this, though. I think we will see this argument again.
I'm going to give an instruction regarding burden shifting. So.
Why not? Why not do both?
I think the conduct is outrageous. And I don't think that
I'm going to try to gain this up. The court said, I'm going to give an instruction about burden shifting. It's a pretty heavy-handed instruction, by the way, but it doesn't change it.
I just think it's outrageous. I think the conduct is outrageous. And I don't think that a curative instruction can do anything except bring the point home again.
Okay.
But if the court is not willing to allow her to testify to her full opinion to a reasonable degree of scientific certainty, can she at least testify that she reviewed the arm, looked at the arm, and it's consistent with an animal? And we at least split the baby.
I will do that. I will allow that. Yes. Over the Commonwealth's objection.
Then I look to have the cross-examiner, because if you're going to allow a consistent opinion with the dog.
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience,
She has the
saying
foundation.
animal.
The foundation has been well fucking laid. Are you joking?
Mr. Jackson, you have to lay a foundation. In her experience, saying animal bites.
Is consistent.
This is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything, that will include
Looking at the arm.
a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
Why?
So no visuals.
No visuals, just that one sentence that
What about
that's
the arm?
consistent with what she has seen.
You can't just tell them you can ask this one sentence and not this sentence.
It's an animal bite. A brief foundation, because I'm letting that statement in as long as she has said, as long as she testifies that she has seen animal bites over the years.
Were you there yesterday?
That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson?
No, both.
Okay.
The defense argued this morning that they should be allowed to ask Dr. Laposata about the opinion that the injuries to John O'Keefe's arm are from a dog. The court said she wasn't going to allow it, but she was going to give a burden shifting instruction. And then the defense said, can we at least ask if the injuries are consistent with an animal bite? And the court said yes. And then the Commonwealth said, well, then I need to be able to cross-examine on it if it's a dog bite. And the court said to Alan Jackson, well, he said animal, not dog bite. And Jackson said, well, I will take what I can get. But they asked quite consistently Dr. Russell about Dr. Laposata. And the court said, well, if the foundation is laid. Yesterday, we heard how many different autopsies Dr. Laposata has been involved in that include dog wounds. We won't just say bites, but dog wounds, bites or scratches. And that she has taught courses regarding pattern injury recognition, including animal wounds, dog bites, claw marks, and wounds. And so Brennan is asking, well, then I need to be able to cross-examine on it. And then at the end, she's like, so you don't want the instruction on burden shifting? I will be very curious to see if these questions end up just opening all the way back up into, are these injuries consistent with dog bites that you have seen? I won't be surprised if we end up all the way back there.
Did you note whether or not the medical examiner, Dr. Scortibello, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate,
Along with something else?
along with the blunt force head injury.
Do you agree
it was
with
blunt
or
force
concur with
as
blunt
the
force head injury
primary.
as
Yes,
a cause of
Miss-
death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment.
It has been suggested that Mr. O'Keefe's right arm, doctor, was injured by contact with the right rear taillight of
That's
Ms.
the
Reed's
issue.
2021 Lexus LX570.
Objection.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think of.
So,
Oh, I'm sorry.
yes, I'm going
It's
to
not
strike
her.
that question and answer.
Let me ask it a different way. Let me ask you a different question.
And for the lawyer to try
Do
to
Mr. O'Keefe's pattern injuries on his right
constantly
arm,
reset is
do they
dumb.
correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
She turned over these opinions. The court said she was allowing these opinions in. The court said she was allowing her to say animal, not dog. Are we not allowing it now? Like, what has changed?
In your report, Doctor, you indicated that Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes,
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
And again,
You
this
also
is not,
wrote that you know
he's now just reading in the opinions from the report because the court wants it said this certain way. But it's not the witness's fault.
Mr. O'Keefe had no
he's
bruising
just reading
on
it
his
in.
arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
All right, I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right, work it out. If you can't work it out, let me know. I'll come out before the jury.
All rise for the court, please.
The jury went out. The doctor went out. I presume they're on morning break. The court said, I've received a motion regarding the curative instruction, regarding, I'm assuming, John O'Keefe's hoodie, because that's what we know is coming. And the court said, I'm not doing this today. We can deal with it at the charge conference. The charge conference means the jury instruction conference when they talk about the jury instructions. And then the court told the attorneys to just work it out. That's not regarding the charge. That's likely regarding what they approached about in court, the big papers that Alan Jackson had when they went to sidebar. That's not going to be regarding the curative instruction. What an incredibly disjointed morning it's been to the morning break. Dr. Laposata's opinions came in through mostly Jackson reading in her report directly that the injuries to John O'Keefe's arm are not consistent with flying pieces of plastic, that they are linear abrasions, they are consistent with claws and teeth. We heard her testify to. Whether it was stricken or not, I can't even remember because there was so many starts and stops. That John O'Keefe died primarily and solely from the blunt force injury to the back of the head that caused the injury to the brain and the fractures to the skull, that hypothermia was not present, that the indicia of hypothermia was, in fact, in her opinion, caused by the Lucas resuscitative machine. The injuries to the arm happened prior to death, not after death, based on the way that the injuries to the arm reacted, which we've heard from the other experts as well. And I think that's where we got towards the end of direct examination, I think, as we got to the morning break, and the court saying, I'm not addressing the curative instruction request now.
To remind the court, on direct examination, the defense promoted Dr. Laposata's credentials, including specifying her successes with the station nightclub fire and her running of her office. I have an audit from 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, They investigated the chief medical examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Laposata. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Laposata's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Laposata resigned. In addition, it was promoted that in the station nightclub fire, Dr. Laposata had a heroic effort, and in her testimony, she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene.
She said she sent an investigator
for at least 17 hours, directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding
you can't ambush. You have to show the defense
resignment after she was
anything
audited
for impeachment.
And left 1,500 bodies unattended or incomplete. Also get into the criticism.
What were the dates on that?
For her handling or lack of handling of the station nightclub fire, and finally get into the credibility, adverse credibility determination in the Patino case.
The backlog issue, if we can call it that, with the ME's office. I'm going to allow the Commonwealth to get into that through questioning. Same with the station nightclub fire, based on the testimony already in evidence. Those two areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those two will come in. I'm not going to do anything with Tompkins because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well. Okay?
So we're not done with this. The jury's out at lunch, and the court is doing the work that needs to be done with the attorneys after sidebar, where Brennan is arguing to bring in impeachment evidence to question Dr. Laposata about, and the court ruled on 3 of the 4 items, 2 of the items being criticisms of her as the head of the ME's office in Rhode Island. When Jackson argued against it, he said, look, these things are explainable. Well, if they're explainable, that's fine to allow the questioning to come in. The reason the court is allowing those questions to come in is because it's similar things that Dr. Laposata criticized here. It was brief, but said, no, you should have someone go to the scene. It should be a continuing investigation. It should be a team that works together. And so if there's criticisms like that out there regarding certain things, the prosecution can ask about it. I have a feeling that her answer will be, yes, when this started happening, I walked away from my job. So I don't know if that's going to end up being the serve that he thinks it is over the way that coroner reports were getting completed or not completed when she was the head medical examiner and a new party came in. So that's going to come in an impeachment, the same way Jessica Hyde was questioned about the case when the court didn't allow her to testify to certain aspects. And that might also come in because the court has kept out one case where the court questioned the doctor's testimony. The second case where a court found her to not be credible. The defense hasn't read it. The court hasn't read it. They're going to read it. That is how Hank Brennan represented it during his argument. The other parties are going to read it and see if she's questioned about it. So with the investigation or the audit of the office of the medical examiner, it seemed like the time range that audit was done was not the entirety of the time she was there. So that will be interesting. The criticism of her office not rolling out to the fire seems, well, I've got questions about it because she said we had someone on scene. If the criticism is that she personally didn't go out, but investigators from the ME's office were out, I think it's silly for the prosecutor to ask about. We're going to have to see because, well, you didn't go. Well, she's the head of the office. If individuals from the office went, does she really need to be there? We'll see how that line of questioning goes. And then there is one other case that they're going to read over lunch, and we'll see if the court lets that in to question the witness about for impeachment. I don't know if either of those things are going to come in the way that Brennan thinks that they will, because this witness is not giving him an inch. Then the court's going to read the case law. And now we had the court marking the presumed, at this point, x-rays on the large paper. And now we are getting back into what Dr. Rentschler will test about, presumably after lunch at some point today.
Mr. Brennan, you argued for 4 points of admission.
Yes.
Regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in.
She said no on 3.
Because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar. All right. And also I had a chance to look
not
at the
allowed.
actual exhibit regarding what came into evidence.
Before the lunch break, the Commonwealth argued there were 4 things they wanted to be able to get into with Dr. Laposata. The court said yes to 1 and 2, no to 3 and 4, which are the cases. So 1 and 2 is stuff that happened while Dr. Laposata was in her position. Part of the reason that is coming in is because the defense went through a substantial list of accolades and awards and things that she had received. So it is fair that the Commonwealth then gets to come ask, but there was also this audit and there was also this. So the court said yes to 1 and 2, no to 3 and 4.
If we could play video E, please. I want to ask you, Dr. Laposata, have you seen this video before?
Is it the one where the foot gets run over? Yep. It's not Randy.
No.
Thank you. You can take that down. Did you see anything in that video that would suggest any contact between that mannequin and the vehicle's bumper?
Objection.
I'm going to see you at sidebar on this for just a minute, please. All right, so jurors, I am going to strike the last bit of questioning of this witness and the video as it goes to this witness. All right.
Dr.
Okay,
Laposata.
hold on one second. Jurors, when I strike something, that means disregard it. And what I've struck through this witness, the video that you just saw and some of the testimony means that if it's in evidence, it's in evidence, but it is not part of your consideration with this witness. Okay. All right, go ahead, Mr. Jackson.
May I proceed?
I think my speculation, I think one of the jurors asked the question of the bailiff that stands back near them.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case. and we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that.
I appreciate that it's like, here is the car, here are the medical records, here are the photos. Can you tell us what happened?
Was it.
I appreciate that
Did you
approach.
follow those instructions?
I did, yes.
Yeah, I appreciate that approach.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies in your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
And?
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research and tolerance values that it would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact with the car? So one of the things we did is we took a head form, the head from a dummy basically that's
Right.
instrumented with accelerometers.
Dropped it.
And we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant
injuries.
fractures.
Right.
For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner to
wouldn't
strike just
also
the head and not have
neck and
subsequent
injuries.
concomitant injury to the neck or any other part of the body. So my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
At the end of the day, on day 30, yesterday and today have been frustrating, disjointed, and there's been a lot of starts and stops. There is so much case left to go, and yet we are almost done. The defense is on their last witness, Dr. Rentschler, who is the biomechanist from ARCCA. And today the defense briefly went through his prior findings from when he was asked to investigate the case. What I found very interesting is it's really the first time we've heard anyone from ARCCA state clearly what they were asked to do by, well, the feds, the FBI, the U.S. Attorney's Office, whichever entity hired them, those entities work together. But they were asked to take a look at John O'Keefe's injuries and determine whether or not John O'Keefe's injuries were consistent with being struck by the Lexus. We assumed that that's what they were asked to look into. Could this happen? But it's really helpful to hear them explain. We went through the injuries, the medical records, the photos of the car, the photos of the scene. We didn't know what any of the theories were or what the thoughts were on how this happened. And we were essentially asked, these injuries, this vehicle, this scene, can you tell us what happened? And can you tell us if these injuries are consistent with being hit by the vehicle? And he went through how he was trying to rule out what could have happened and the way they evaluated that, including taking one of the crash test dummy heads and seeing if the head hit the back of the taillight, with like the taillight going about 15 miles an hour, the car going about 15 miles an hour towards the head, if you could recreate those injuries and the skull fractures that John O'Keefe had without, he said, concomitant injuries to the neck or the rest of the body, and trying to figure out how could this substantial and significant injury to the back of the head happen from a collision with the vehicle? And then how do the arm injuries happen? Because it's not just the injury to the head. And he was saying he found that the arm injuries were also inconsistent with being hit by a Lexus, which was ARCCA's findings from the first trial, which the shit's out of the horse on that. And it's just first trial, this trial at this point. It's just that's where we're at. So we got through his background, the things he's done at ARCCA, what a biomechanist or biomechanical engineer does. We talked a little bit about force and load. We definitely didn't have any conversation of spreading the load. That didn't happen. And we didn't get to talk about, the force involved in things like water polo, frozen water sports. Yes, hockey, lots of conversations about hockey. We didn't get all the way into his testimony because there were still rulings outstanding from the court about his PowerPoint presentation. And the court went through and issued rulings saying that the text needed to be taken out of a whole number of the slides that were objected to by the Commonwealth. And so overnight, the court, it seemed, asked the defense to have two versions. The court said there was still a ruling pending on slides 9 through 23. If there was a way to have the presentation edited with the text being taken out of all of the items that she listed that had been objected to prior to the break, where Brennan went through one by one, objecting to the text, and then said separately, after editing the text out of all of those, could we also have a version where slides 9 through 23 may come in, may not come in, depending on foundation. So we'll see what, if any, PowerPoint slides come in tomorrow. And then will we see Dr. Welcher tomorrow after Dr. Rentschler is done testifying? Because there was some conversation about whether Dr. Welcher needs to be back in court tomorrow after Dr. Rentschler testifies for the Commonwealth's rebuttal case. And we know that the Commonwealth has 3 rebuttal witnesses. 2 of them are very quick about swabbing John O'Keefe's hoodie, and Hartnett, who swabbed the hoodie, is going to be the perfect person for the defense to ask about when the cuttings happened and to show the jury that picture that the hoodie did not have damage to it from January 29th. That'll be one of the last witnesses for the Commonwealth, which gives the defense on cross kind of the last crack at, hey, remember, those holes in the hoodie weren't there. We also saw something really interesting today that we have not seen in this trial. I mean, me daily, but the jury, it seemed, asked a question to one of the bailiffs who went and asked the court. And then the court instructed the jury that when the video was stricken out of testimony during the Commonwealth's cross-examination of Dr. Laposata, that didn't mean that the video was out of evidence. It means that the questions to Dr. Laposata about the video at the 29 miles per hour where Rescue Randy's arm was hit and then his foot was run over, the Commonwealth asked, did you see any impact from a bumper in that video? And that line of questioning, any answer, and the video was stricken at that time. And the jury seemed to wonder what that meant. And I think when we saw the bailiff pass Alan Jackson as he was getting up to do redirect, that's what the jury was asking the court about, because the court gave a much more thorough explanation then about what striking the video meant. But what it shows me is that the jury is paying very close attention, and they want to know what they can consider and what they can't consider. That's not a jury that's just like, oh yeah, it's fine, whatever you say. That's a jury that's like, wait, no, what does that actually mean as to this? You've never stricken a video before. We've heard disregard that last question. They've heard it regularly, but they've never heard disregard all of this and asked about it. It shows that even 30 days in, to me, that this jury is paying attention. This jury is dialed into this case, and I'm sure they're ready to get this case to them. The court said at the end of the day, we've picked up some time today. I assure you we're close to getting the case to you. I think the jury is paying attention. I also think after 30 days, they are probably ready for the last few witnesses in this case because they've heard quite a lot. It will be interesting to see what the day looks like tomorrow. And then we're going to need to get to the charging conference. What does the charging conference mean? It's when they talk about the jury instructions. It's often called charging the jury. When you tell the jury what they're to consider, what the jury instructions are, those can take about an hour and a half or more to read to the jury. What are the jury instructions? What are they charged with doing? Ladies and gentlemen, you need to consider this evidence in this way as to these charges. It can be boring to watch. I get it. The jury instructions are one of the most critical parts of a case. The instructions that they get, the way that they are read, is incredibly important. So if, and I hope that it is, if the charging conference is streamed We are going to watch it together. Well, I'm going to watch it. I hope you will join me. I can't say what you might want to do. The lawyers will be gathering those jury instructions prior to even starting trial, looking at the things that they want the jury to be told by the court. And we know that the court is going to wait to take up what Alessi brought up this morning with regard to the charge to the jury yesterday about the hoodie and the holes in the hoodie until the charging conference. So it seems that the defense might have the opportunity to then ask for a stronger charge to the jury within the jury instructions. That's also when we should hear the court take up necessary witnesses, i.e. missing witnesses, who the Commonwealth called, who they didn't call, and whether or not a jury instruction will be given about that. Charging conferences are very important. I'm interested to see it. And at the end of the day, one of my biggest takeaways is that no matter what Dr. Welcher said, there were x-rays done at the autopsy of John O'Keefe. How in the world did Welcher testify that there were none done?
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Because what we saw with Dr. Laposata is that there are sure the fuck x-rays. I mean, they were printed out on huge pieces of paper and apparently also on thumb drives. But did the Commonwealth not give the x-rays to Dr. Welcher? And does Brennan not know that there's x-rays? What? It's going to be very interesting to see. So I suspect that we will see the rest of the witnesses tomorrow, maybe those 2 DNA witnesses, which will take like an hour, maybe in the morning on Thursday, and then maybe the charging conference the rest of the day Thursday. I think the court will kick about bringing the jury in for 30 minutes or an hour of testimony, but then you do the charging conference the rest of the day Thursday and do closing arguments Friday. The defense, when they were chatting, said Monday. I'm sure the defense would like their weekend to work on their closings. If the jury is not going to have time to hear the instructions, hear closing, and start to deliberate Friday, the court might punt it till Monday. So will this jury get the case Friday or Monday is unclear, but we are close to the end of this case. We're in the defense last witness, which means there's a lot of witnesses that weren't called in this case. And we're going to see the rebuttal witnesses starting likely tomorrow. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.